On the 8th May of 2023, the Directorate of Criminal Investigation, hearing the applicant respondent, filed an application dated the 5th of May 2023, which was brought pursuant to Section 118 and Section 121, Subsection 1 of the Criminal Procedure Code and Section 180, Subsection 1 of the Evidence Act. It sought orders to investigate, freeze, and preserve several named accounts for a period of 30 days in the names of Kilifi International School, New Life Prayer Center, and Ezekiel Odera. The court, being satisfied with the material placed before it, allowed the application and granted the order sought, and directed that the matter returns to court on the 17th day of May 2023. On the 15th May 2023, Ezekiel Odero, hearing interested party / applicant, filed an application seeking the following orders. The first and the second one was spent. C, that this Honorable Court review the orders issued on the 8th of May 2023 and unfreeze the accounts numbers. I'll not go into the numbers. In the name of Kilifi International School, account number, I'll not mention it. In the name of New Life Prayer Center, domiciled at Cooperative Bank, and another account in the name of Kilifi International School, domiciled at NCBA Bank. Further, Prayer D, that this Honorable Court review its orders issued on the 8th of May 2023 and vary the number of days stated in the freeze order from 30 days to 15 days. E, that this Honorable Court review its orders granted on the 8th of May 2023 to allow and limit transactions made from the said accounts for the operations of the school, church, ministry, namely New Life Prayer Center, and church, and Kilifi International School, up to the amount of Kenya shillings 50 million. And F, any other such direction to be given, and order issued as the circumstance of this case dictates. The application is premised on the grounds on the face of the application and the affidavit sworn by Ezekiel Odero on the 15th day of May 2023. The learned prosecutor, Mr. Gashoka, on behalf of the Office of the Directorate of Public Prosecution, argued in support of the preliminary objection, drawing the court to the often cited case on the question of jurisdiction, the case of owners of motor vessel Lillian S. versus Caltex Oil Kenya Limited, 1989, EKLR. He argued that this court lacks the requisite jurisdiction to review its own orders, contending that the interested party ought to have filed for a review or appeal before the Superior Court. He argued that upon the issuing of the orders on the 8th of May 2023, the court became factors official. He referred the court to Article 47 of the Constitution on fair administrative action, hypothesizing that such the order sought is within the purview of the High Court, and that this court's jurisdiction will only crystallize and coalesce up after the lapse of the 30 days issued by the court. Mr. Wambui argued that the preliminary objection is misconceived, ill-advised, and, to say the least, as he put it, is a legal misadventure meant to distract the court from determining the application dated the 15th of May 2023. He further argued that the court has discretionary powers to review its own order, considering that there was an error apparent on the face of the record where the court had expressed itself and noted the same. He was of the view that an aggrieved party has a number of options on which to exercise, and that the interested party should be allowed to freely choose which option to adopt. On his part, Mr. Omari contended that there is no legal provision underpinning such miscellaneous application instituted by the applicants, and argued that it is an importation from the civil procedure rules. He submitted that by the state arguing that the court is factors official in an ex parte application and asking the parties to go to the High Court is purely a delay tactic, which constitutes, in his view, sharp practice. Whether this court can grant subsequent orders corollary and concomitant to the orders issued on the 8th of May is only subject to the law and the basis of which the application was brought before this court. This is the road to Damascus which I will undertake. Having laid the basis that the orders granted by this court were legal and sound, let me now delve on the issues before us for determination. Additionally, in the MAPE Building and General Engineering versus the Attorney General, as I've cited earlier, it was stated, and I quote, The resultant seizure ought not to be absolute, but only for the period of investigation. Certainly, the period of investigation must not be indefinite period, if only to ensure that the person's property is not absolutely appropriated or expropriated through a warrant of seizure. End of quote. Further, in the case of Hassan Mohammed versus EACC and another 2019 EKLR, it was stated that, and I quote, owing to many complaints arising from the ex parte issuance of such warrants by the Magistrates Court under Section 118 and Section 121(1) of the Criminal Procedure Code, and for proper management of the process, as a division, we've decided to issue the following guidelines. 1. Upon issuance of the orders under Section 118 and 118A of the Criminal Procedure Code, the magistrate must state the duration within which the order shall remain in force. 2. The duration shall not exceed 14 days.